Hi, my name is Patricia DeFonte, and I'm the founder of DeFonte Law, where we and my team practice estate planning with heart. Creating an estate plan is not filling in some forms, handing them over to a lawyer, and then signing some documents. Estate planning is a process. Some say it's a journey. It's eventful and exciting. It's really, really important that your estate planning attorney has a really strong and deep professional network. What we do cannot be done in isolation. Your estate planning attorney should have terrific resources for you when it comes to insurance, other lawyers, mortgage, sometimes therapists, home organizers, whatever it is that you might need. Your estate planning attorney really should be the hub for you to help you find all of the professionals that you need in order to set yourself up for success. Today, I'm really excited because one of the biggest points of distress for a lot of my clients is when they work with me, I pull a copy of their deed. So I'm pulling a copy of their deed, but I'm also pulling a copy of their mom, their dad, their siblings, their guardians, because what I'm looking for is, does the title make sense or is it just nonsense? And I see a lot of those. And has it been transferred to a trust? Are the people that you are entrusting your children to, putting in charge of your affairs if you can't take care of yourself or when you die, are they organized? And I'm also looking for uh-ohs. We're going to talk about uh-ohs a little bit more later. With me today is Rebecca Larson of Your Home Legal. Rebecca has dedicated her practice to real estate law. And what she likes to do is work with people who are purchasing a home to make sure that everything is set up properly and that you don't miss a trick. Rebecca, why don't you tell us a little bit more about your practice?
Well, Patricia, thank you so much for having me. I'm Rebecca Larson. I own Your Home Legal. I work with buyers and sellers throughout California, managing the risk that happens when you're buying real estate in California. We're one of the most litigious states in the country, and our real estate is also one of the most expensive. And there's a lot of things. Patricia actually said it really great when talking about estate planning. It's not just signing a bunch of documents and being done with it. There's a lot more that goes into buying a home than signing your contract, signing your loan agreement, and then getting the keys to the house. We're going to talk about some things that come up during the escrow process where you may want to consult with an attorney to make sure that things are going to be handled correctly. So, passing it back to you.
Why don't you give us an idea of who you typically work with? Do you do both residential and commercial? Tell us a little bit about your practice.
Sure. So I primarily work with residential buyers. And when I say residential, that is, you, when you're buying the home that you're going to live in, or the home that you're going to sell. I also work with real estate investors on their investment portfolios. So, setting up their LLCs, putting together their purchase agreements and their disclosure documents, and helping them through their process of buying an investment property. But my primary focus has been residential, traditional consumers. So buying the home that you're going to live in. On the commercial side, the office buildings, industrial parks, I work in that space, and it's generally a limited scope for leasing. So I'll work with the landlord or a tenant on either reviewing or negotiating their lease agreements.
So when someone is thinking about making a real estate purchase or selling a piece of real estate, how early in the process do you want to see them, and how are you helping them set up these, let's say, the preliminary phase?
I mean, if I had my way, it would be before you called anybody else, call your attorney, right? And even if it's calling, Patricia, calling your estate planning attorney or calling your family law attorney, call an attorney first and say, this is the thing that I need to do. Because the way that Patricia and I work, we are really well connected to anybody that you're possibly going to meet in this process. Your real estate agent, your lender, your insurance people, your tax advisors. But what we can do is we can start troubleshooting what is your actual goal and what do you need to do to get there? A lot of times where people are coming in is, I don't want to say it's too late, but it's not the ideal time. So they're coming in after they've already signed a contract, either a listing agreement or they actually have a contract for the purchase or sale of their home. And now it's I don't know what I just signed. I've got a weird feeling in my stomach that I need to know some more information. And at that point, especially if they're already under contract, there's really not much I can do other than I treat it like buying a ticket to an airplane, right? Right? You buy your airplane ticket, you go to the airport, you get on the airplane, you're already there. You're sitting in the seat, and the flight attendant's giving you your safety briefing. right? In the unlikely event of an emergency, or here's how you get off this tin can. That's sort of what it's like when you're already signed the purchase agreement. Here's your ticket, and here's how you can get out of this thing if you absolutely have to. But in an ideal world, you're calling me before you're selling, you're calling me before you're buying, so that I can make sure that we have all the bases covered, because there's so much that can go on during this escrow process that not only relates to just the purchase, but everything else that comes with it, like your estate planning, like family law, like taxes, that you may not even know are issues that you need to be worried about.
Tell us a little bit about escrow instructions, because you really specifically wanted to address this.
So escrow instructions, and in the chat, if you bought a home in California, just let me know. And when you buy a home and you've signed the purchase agreement, the next step is your contract goes to the escrow company. The escrow company then sends you a package that says, here's all the stuff that we're going to need from you. One of the documents that you're going to get are their general instructions for escrow. Tells you who they are, what fees they're going to collect, limiting all their liability. But buried in that little package is going to be a one-page document that's going to say, tell me how you want to hold title. And you're going to be like, I don't really know. There's going to be a line for your information where you're identifying yourself. If you're buying it with somebody else, who they are, what is your marital status, and how do you want to hold title if you're buying it with somebody else? How do you want to hold title with them? Meaning, how do you want to own it? When you own property, there's a couple of different ways that you can hold title depending on who you are and who you're buying your property with. Sometimes the escrow company will give you a little one-pager right behind that it's like it's a chart that tells you the different ways that you can hold title and how they work. It makes sense to me because I went to law school, right? I cried my whole way through property law trying to learn this stuff, right? But most of the time when you look at this, you're like, okay, well, this makes sense because I know how to read and I understand English, but you don't actually understand the full implication, because when there's a problem, it will almost invariably be too late to fix it, because there's going to be one of three things happening. You're dead, you're getting divorced, or you're breaking up your business. And at that point, it's game over. So it's now a matter of damage control. How do we fix it on the other side? So that is like the most important question that a buyer needs to answer during this process is, how do I own property with this person?
And I want to speak to that a little bit. Just this week, I had clients write to me in an absolute panic. Hey, we're getting this HELOC and the lender doesn't like our deed, and they're telling us that we have to choose one of these. Well, my team had told them almost a year ago, we don't like the way you hold title and this needs to be fixed. They decided not to take our advice. And the lender was pushing them, the title company's pushing them, make a decision, make a decision. Now, here's the trick. As an estate planning attorney, I have no idea how you should hold title. I know what the tax implications are on one death and then a second death for a couple. I know what the implications are on divorce, but I don't know what you should do. And so that really is the purview of a family law attorney, not a real estate lawyer, not an estate planning lawyer, but a family law attorney. If you are very, very unsure as to whether or not, as a married couple, you should own it as community property or a joint tenancy, and do you want to write a survivorship, all of that has to be explained to you. And leaving that until the last minute will make you insane. It will absolutely make you panic. And sure, you can go back and try to fix it, but going back and fixing it is expensive. And it used to be that estate planning lawyers would say, oh, you own this in a certain way. And I'm not even going to call out the different ways. You own this in a certain way. There's a tax benefit if we change it. I'll explain it all to you. What do you think? And estate planning lawyers used to make those changes. Now, first of all, that change could come back to bite the estate planning lawyer if the married couple gets a divorce. More importantly, because a good estate planning lawyer will have insurance and it will be okay, is that what that estate planning lawyer did might not work. There is case law that has come out of the bankruptcy law courts and also the family law courts that tells us that if you are changing the way that you own something, you're changing what is stated on the face of your deed, if it's not done absolutely 100% in accordance with family law, that it may not work. And so I might think they're going to be together forever. It's going to be wonderful and I'm going to change it. And then they are together forever and one of them dies. And the survivor doesn't get that terrific tax treatment that I had anticipated because someone at the assessor's office knows their case law. So it's really important to, I love what Rebecca said, call your lawyer. Everybody should have a lawyer. I'm usually the only lawyer my clients have, but I'm always here to introduce them to a real estate lawyer or a family law attorney. Can you talk about taking title with people that you are not married to, Rebecca? Let's dig into that a little bit.
How much time do we have?
Oh, I know.
Because we can talk about that for hours and all of the horror stories that I deal with clients who bought a piece of property and I'm boyfriend, girlfriend, right? Or significant other, right?
Well, why don't you tell us what are the options? So if you're buying real estate with someone that you are not married to, your options in California for taking title are?
You have two. Well, two. Technically, we're just going to deal with two. We're going to deal with tenants in common and joint tenants, because those are the two that are most often used for if you're buying property with a significant other. There's another option for real estate investors. That's really outside the scope of what we're talking about. But for, if you're buying a piece of property with a boyfriend, girlfriend, significant other, someone that you're in a romantic relationship with, you really have two options: tenants in common and joint tenants. There are so many issues just between those two types of how do we hold title, right? The vesting. But there's also so many issues on the back end of this. Okay, great. We own a piece of property together. Now what? You're not married, so you don't get to go to family court and get the benefit of all the family law rules that we have regarding division of assets. So what happens when you break up? How do we get out of this relationship? How do we get out of this piece of property? Most people don't, because they don't even know that this is a thing, because they think that they're going to be together forever.
Yes.
Right.
Absolutely.
And
absolutely.
I hate to rain on their parade, but it's not happening. Right. And forever ends in death too. Right. So that's the other part of it is you could potentially stay together forever. You don't ever get married, but your relationship will end at some point, either voluntarily or involuntarily, because someone dies or because you guys just break up. But you have to have some sort of agreement between the two of you, that or three of you or four of you, however many people are buying this property, that says, this is what I'm responsible for. This is what you're responsible for. This is what we are responsible together. And this is how we're going to get out of this in the event that we want to sell it because we want to go buy something else, or because we're breaking up. This is how we extract ourselves from this piece of property.
Exactly. So I think it's important to let people know that if you are an unmarried couple, you are legal strangers. You can be together for 50 years. The state of California does not care. You are legal strangers. And if you break up, it might be that a really good family law attorney can go after your ex for a portion of their real estate, right? Or they can come after you for a portion of your real estate and other assets. It's really important to note that if one of you dies, the other one is a legal stranger. And sure, maybe you could litigate and say, well, under the family law code, if we'd broken up, I would have gotten X, Y, and Z. But there are horror stories where this happened in one of my mother's groups. She had two toddlers. She's living with her fiance. He is not the father of her children. And he dies. He was 35 years old and just died. She's living in his house. His family threw her out. It is really, really important if you're living in someone else's house to take care. And it's really, really important if you are not married that you take the time to give each other the right to inherit from each other. Sometimes
if that's what you want.
Yeah. Sometimes on a deed,
right.
Talk about the right of survivorship. Now, is that available in a tenancy in common?
No. So no. Tenants in common, you have no right of survivorship. So let's say Patricia and I buy a house together and we own it as tenants in common. This is also the only way that you can own property in proportional interest. So we could own it 50-50, but Patricia, because Patricia's Patricia and she's up in the Bay and she's got buku bucks, I'm just kidding. Right, she's a 70% owner, I'm a 30% owner. That's the only scenario where we can have unequal ownership rights. She's a 70% owner, I'm a 30% owner. And the way that shakes out is when we go to sell it, right? She's going to get 70% of the equity. I'm going to get 30%, or whatever we agree to in a separate contract. But the way that the deed would show, it would show Patricia at 70%, it would show me as 30%, and then it would show us as tenants in common. We're also missing a little segment in there about our marital status, because that also makes a huge, huge, huge impact on how we hold the title and what the title companies are going to want, and the estate planning issues and the family law issues. So if we're buying a piece of property together and we're holding it as tenants in common, if I were to die, and I'm also going to throw in a little estate planning bit on here, I'm going to die and I have a 7-year-old daughter. My 7-year-old would inherit my 30%. And now Patricia, unfortunately, is going to own a piece of property with a 7-year-old.
Yes, and I'll make that even worse. Let's say that you and I are married, and this is
Right.
no, you and I are a couple, and this is our child. So now there I am owning this property with our child, and a court will appoint a guardian ad litem to decide what's in the best interest of the child, and could even force a sale or get in the way of me doing a refi. Every step I wanted to take with that piece of real estate going forward would have to be approved by the court.
Yeah, and let's put a pin on that, because we're going to talk about adding children to title, and children, minor children and adult children.
Oh, we're going to get to that.
We're going to get to that. So don't worry, it's going to get fun.
But I think it's an important point between unmarried couples where they have children together. They're not going to inherit from each other in the absence of a solid estate plan. The children are going to inherit. And now you've got parents inadvertently, not meaning to, own real estate with their children, and it is a disaster. With minor children, it is an epic disaster.
It's a disaster of epic proportion when you end up inadvertently owning a piece of property with a minor, because it's so expensive. It's such an expensive mistake to have.
So we talked about
survivorship. That's the tenants in common. There's no survivorship. So when I die, Patricia's not going to own my 30%. My kid is. If we were to own this piece of property together as joint tenants, that does have a right of survivorship, which means when I die, Patricia then owns the whole property. But wait, I don't want Patricia to own the whole property, because I want my child to inherit, part of my estate. I worked my butt off to buy this piece of property, and I want my kid to be able to benefit from it. So because I didn't have the conversation with my attorney, with my estate planning attorney or my real estate attorney, when Patricia and I were buying this piece of property, and nobody told me, like, this is the practical way that when you check this box, this is what's going to happen down the road. I didn't know. And I'm too dead to fix it.
Yeah, you're too dead to fix it.
I'm too dead to fix it. And my kid, who's 7, she doesn't know that she potentially has a claim. Maybe somebody in my family who are a bunch of non-attorneys, maybe they would know to ask those questions, but it's too late to fix. That's the only scenario where, if we're unmarried, those are the 2 ways that you hold title. Tenants in common, no survivorship. Joint tenants with survivorship, but then there's all those other issues that could come up.
And you have to be really careful, because some people think, well, it's joint tenants, so automatically you have a right of survivorship. But it's not true.
No, it's not.
We actually go all the way back to, I think, the first week of law school, where we talk about the 4 unities.
Yes.
So in order to get survivorship,
you have to actually specifically say it. You have to say joint tenants, comma, with the right of survivorship. Because if you don't, there's a presumption that there is not a right of survivorship, which means, great, you're in litigation enforcing the intent of survivorship.
So we have a really long question that I'm going to read, but while I'm reading that and teeing it up, I want you to talk about adding kids to the title. And I want to tell a story. Because I pull deeds for all my clients, we did find that a client's mom in Modesto had added all 5 of her children to the deed of her home, because somebody told her that's estate planning. She also included the youngest, who was about 19 and already had 3 DUIs and no insurance. It was actually pretty difficult to get him off the deed, because once he was told that he owned 1/6 of the house, he didn't want to let it go.
Right.
This put mom at risk, because he is absolutely going to go out and incur liability. He doesn't own anything. Oh, wait, he owns part of mom's house. It also, from an estate planning perspective, is a tax disaster for everybody involved, because you're not going to clear all the capital gain that's on the house only the part that mom still owns when she passes. So it's a mess. And now, under our new real estate laws, as people die, it's going to trigger a reassessment. So mom
Reassessment.
puts one of her kids on title to the house, that one dies. Are we exposing ourselves for more taxation? I don't know. And people do this with their primary residences, and they also do it really commonly with vacation homes. And it's just a danger zone. So,
Yes,
Rebecca, tell us what you've seen, and I'm gonna read this long question, and I'll have that teed up for you.
that sounds great. So let's actually talk about that 19-year-old troublemaker, because that's what's going to happen. When you add your kids to title, you're inheriting all their garbage. So the 19-year-old with 3 DUIs, maybe he gets slapped with a civil, maybe it's a DUI with a car accident, maybe he's done some damage to someone, he gets sued, and the family sues him. The insurance, doesn't cover it because he's 19 years old and has minimum coverage, right? He gets a judgment against him. And how can you collect on a judgment in California? And that's by taking that judgment and recording it with the recorder's office wherever they own property. And great, Junior owns a sixth of mom's house. That judgment's going to attach and stick to anything that Junior owns, including mom's house, which means if mom wants to go sell the property, mom wants to go refinance the property, that lien has to be taken care of. And that lien could be $1,000, that lien could be $1 million. And that's just the problem that is going to come up with that kid. But judgments in general, so any piece of property that you own and you get a judgment against you and they go record that judgment, it's going to stick. And it's going to, you don't know, because especially if you're having this, if you're doing this without consulting with an estate planning attorney who's actually going to go pull chain of title and look to see what's on, and also doing due diligence on the kids that you want to add to title or the beneficiaries, and you find out what their dirty laundry is, because your 19-year-old probably not going to tell you that he got in trouble. Maybe he will. Your 30-year-old probably is not going to be telling you that they got in trouble. Maybe they will. But if you can go and do a judgment search, you can say, listen, he's got a bunch of judgments. If you add him to title, those judgments are going to follow him and stick to the house. So you might not be able to do things in the future because of those judgments. Here's what I've seen a lot. They add their adult children to title, and the adult child gets divorced, and they have child support liens. Those are fun to deal with. And when I say fun, it's not fun at all. You've got to deal with the county to get the payoff. But those things are also things that could potentially follow your kid when you add them to title. A little overlay on the family law, depending on how, when you add the child to title and what their marital status is, you might be then dealing with, when your kid gets divorced from their spouse, dealing with a claim by the family law, in their family law case, for a potential claim on the equity in that property. Because, well, he owns this property and maybe they were helping mom pay the mortgage and, they were using community funds to pay for it. It's just a mess. Now you've got to deal with your kid's divorce. No bueno, not fun.
No bueno, not fun comes up a lot with DIY
it comes
real
up a
estate
lot
deals.
Right, DIY real estate and DIY estate planning, because someone told them somewhere, all you need to do is add your kid to title, and don't worry, it's not going to pass. It's going to pass outside probate. It's going to, don't worry, they'll get the house.
Rebecca, have you run into people who have these oral agreements or side deals about real estate? I've worked with quite a few real estate investors, and their name is on title to the house, and they're telling me that, but they actually own this with a buddy.
Yeah.
And the buddy is helping with the payments. And so talk to me a little bit about that scenario.
Yeah. I mean, if you're the buddy that's helping make payments and you're not on title, you probably shouldn't be doing that. Right. And this is similar to, like, think about it in a spousal sense, right? If you're married, you're the spouse that's not on title, but your money is going to pay for the mortgage. Like, especially if you're paying the mortgage, like, how do you protect yourself? By staking claim. How do you stake claim? By getting on title. And if you've got a spouse or significant other that's like, yeah, no, I'm not doing that, you might want to reconsider the relationship that you're in, right? Like, why are they taking your money and not giving you what you're worth? But on the real estate, there's a lot of, I don't want to say that all real estate investors are shady because they're not, right? But you hear the
No.
horror stories about the guys who have these backdoor deals, and there's somebody involved, and they're a silent partner. There are
I'm
ways that you
adamant
can.
about clients cleaning this type of thing up, because what I am afraid of, if you own a piece of real estate and your name is on the title, and maybe it's even you and your spouse are on the title, but there's this other person who helped with the down payment. There's this other person that is helping to pay the mortgage, that is somehow involved. When you die, you are leaving your spouse at risk of litigation.
Right.
Now, real estate deals generally have to be reduced to a writing in order for them to actually work. But we
They
never
always
know.
have to be reduced to a writing.
And yet we never know what a judge is going to do.
Right.
And so
True.
I would just prefer that everything be teed up properly and have a bow on it. And I have absolutely pushed clients who created their own LLCs, are doing these types of side deals, to clean it up, because what you are potentially leaving is an absolute mess for your spouse or your children in the event of your incapacity or death. Real estate deals are a really big deal. You should not create an LLC on LegalZoom and think you know what you're doing. Do those limit your liability, Rebecca?
Let's just say no.
No, they don't, because there are things that you need to do to limit your liability.
Right.
So here's the question. It's more of an estate planning question.
Okay.
And this comes up in my practice all the time. So let's say that an older couple, and they hold title to the real estate as joint tenants, and then one of them dies. Now, generally in a joint tenancy, when one of them dies, if the survivor sells, the survivor is on the hook for capital gain for the portion that they own. There's a different result if they hold title as community property.
Community property with the right of survivorship.
The surviving spouse can sell and not be exposed to capital gain, or they could decide, I want to keep it and leave it to my kids, and then the kids aren't exposed to capital gain. Now, it's a little bit tricky because sometimes people take title as joint tenants because someone at the title company said, everyone does it that way. Never take advice from anyone at a title company about how you should take title. You are not their client. The lender is their client, and we do not listen to anything that anyone at the title company says. We ask our lawyer, okay? That is the rule. So a lot of people hold title as joint tenants. I ask all my clients, where did the money come from? How did you pay for this? And sometimes the horror is, my mom gave me $1 million and I bought this house and we took title as community property. Oh my God, if you divorce, he gets half. And they're horrified. More commonly, well, we've been married for a long time. We've been working hard and we saved up and we bought this house. Well, why didn't you take title as community property? We don't know what that is. And so as to what happens in the real world when someone dies, it really depends on the jurisdiction and how aggressive the taxing authority is going to be as to whether or not something that says joint tenants on it is actually going to be treated as a joint tenancy, or with good lawyering, we can get that viewed as community property so that we receive the double step up in basis. So it really is a case by case. What I like to do with my clients is I like to get it cleaned up, because I don't want widows and widowers fighting the tax authority. I don't want widows and widowers having to do petitions. I don't want them getting in an argument with title companies, lenders, anyone. I want everything clean, 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 clean.
Well, and just, it's not all doom and gloom. So if you did check the box, right? If you did check the box and you're like, I don't know what I did, even if this was 10 years ago or 20 years ago, and you just like, I don't know how I hold title to this property because you haven't refinanced, or if you did, it clearly never came up and you just don't remember, just ask, because both of us can pull these deeds just to say, here is a copy of your deed. And if you want to learn more about what does this actually mean, let's talk about it.
Yes.
These things can be fixed, but you have to be alive to fix them, and you have to have capacity to do it. So if you're ever in doubt about how you own any real estate that you have, just ask the question. I don't know. Can you help me understand it? Because we can fix it. While we're still alive, we can fix these things if they need to be fixed at all.
I think we need to talk a little bit about Prop 19.
Oh my God. Okay.
So, the old rule was that you could leave your real estate empire in California to your kids, and they got to pay the same amount of property tax that you pay. They keep your Prop 13 property tax basis.
Right.
Oh, voters of the state of California, you unwound all that for all of us. Yes, it's our own fault as voters. Page 1 of Prop 19 said, let's help out people over 55 and fire victims so that they can move anywhere in the state and keep their Prop 13. That sounds nice. Page 2 delivered a giant black eye to anybody who owns the brick and mortar for their business, because when the kids inherit that business, I don't know, the price of cupcakes is going to be like $15 a cupcake, just so that a bakery that owns its brick and mortar can actually afford to stay open, because
Right.
they're going to get reassessed. And when it comes to your residential real estate, only a home that is being treated as a primary residence escapes this reassessment, and then only up to $1 million.
Right.
Just earlier today, I was asked, well, what if a parent now, before death, were to transfer real estate to their child? Does that trigger reassessment, Rebecca?
It depends.
Talk us through it.
It depends. So Prop 19, the 1-2 punch on page 2 of Prop 19, where it removed the ability for parents to transfer real estate, residential and commercial real estate, to their children up to $1 million. They basically kneecapped property owners in California from doing that. Now you can only transfer real estate to your children if it will be the primary residence of the child, which effectively eliminates all commercial real estate. So even if they're transferring an apartment complex, right, and the child lives in one of the units of an apartment complex, tough, ain't happening. It has to be the primary residence of the child. And nobody was paying attention to this. And it's not surprising, right? We were, 7 months into the pandemic. There was a lot of other stuff going on. And this was one of many things that was happening in 2020 that we were dealing with. And it did sound nice to help fire victims. And it did sound nice to help, our aging population, which to me is kind of hysterical, right? Like, we want to be able to help 55 and older be able to afford property, with also not taking into consideration that a lot of times that community, their only asset is the home that they're living in, and they want to be able to give that to their kid as, their inheritance, right? They want to be able to provide a home, and they want to be able to provide, something for their kid to benefit from. So what this effectively does is the kid has to, one, reside in that property, which we all live in California. We all know how expensive it is. We're not going to beat that dead horse. What a lot of people are not realizing, though, is that when they're doing these transfers where they're adding their kids to title now, how it's triggering the reassessment, because the child is not residing in the property. And it's going to trigger, depending on if they do an outright transfer to the kid because they want to do a lifetime gift or whatever reason they're giving the property to the kid. And they're like, okay, we've owned this property since 1985 and the property taxes are, $1,000 a year. Today they are. Tomorrow they will be 10,000 or 12,000 or 15,000, and your kid can no longer afford to live there. So now you have to sell it, and now you're dealing with tax issues. Yeah,
it's ugly, and it's
that
hard.
being said, right? Like, yeah, it's a law, but I think the more vocal that we get as a community about this really has devastating effects. Because I don't know if you guys remember seeing the literature about keeping East Coast trust fund babies out of California. Do you remember seeing that?
No.
Oh, that Southern California got hit with that. That was what was in my mailbox pretty much every single day. These flyers with, frat boys looking people saying that they're going to be, taking over all this coastal property because they're going to be inheriting it from mommy and daddy. And we're trying to keep that East Coast money out of California. Could not be farther from the truth about who's actually benefiting from this transfer in real estate property tax basis. It's Californians. It's your mom and your dad transferring the property to you because you want to stay in California. It is not benefiting the 7 trust fund kids on the East Coast who might get a property in LA or La Jolla or Malibu or whatever. That's not who that's benefiting. And let's talk about our Central Valley and our desert and our NorCal, homeowners, right? It's just, sorry, this is another one we could talk a whole bunch about.
This is why I say that estate planning is a social justice issue. I find this law racist, classist. If you are not in the stock market, if what you believe in to create wealth for your family is real estate, everyone's going to have somewhere to live. If we need to go to the mattresses, we know where we're going. It's real, it's tangible. I don't understand the stock market. All of that now has been ripped away. And if you're renting, don't think that this doesn't apply to you, because when your landlord dies, whoever inherits from them, and whether it's someone who inherits or somebody who buys the property, it used to be the heirs would inherit same Prop 13 and they could deal with your rent. Now they can't deal with your rent because your rent doesn't cover their property tax.
Right.
And you would say, well, if they can't afford it, they can sell the building, but that doesn't solve your problem of whoever owns it can't afford that property tax on the amount of rent that you're living. And they will figure out a way under the most stringent landlord tenant laws to get you out of there. And so this is something that's going to have a ripple effect on every Californian in residential real estate and also in commercial real estate. Because again, that bakery, that auto repair shop, all those little mom and pop stores that are providing great services, how can the next generation afford to operate that business? Or how can the next tenant afford to pay a high enough rent so that the landlord can at the very least keep up with their property tax payment?
Right.
Your
Right.
entire commercial corridor is going to change. Call your assembly person and complain.
Agreed. Because that's the other thing is that, yes, we have this law, but the laws change, right? And if we're vocal enough about this can change. There was a lot of money put into this. California Association of Realtors, I think, correct me if I'm wrong, I think they spent something like $40 million in lobbying for this.
I think they drafted it.
That's not surprising at all. But the California Association of Realtors, and if you think about the timing of this, right, we were in there's no inventory, right? This is a way to free up more properties that would never have been on the market otherwise. At least that's the logic behind it. But it does not help us as Californians unless you look at it. Okay, great. We're bringing in more tax revenue, which means we can potentially have more revenue available for services. However, even if I ran these numbers in 2020 when this was all going down, the amount of money that would go into the general fund for the property tax reassessment is so negligible. It's so negligible that it's embarrassing that was it's embarrassing that Californians were duped into voting for this because of the perceived or proposed benefits that these increased tax rates would actually benefit your local community. The dollar amount is so low that it basically does nothing for your general fund.
Okay. Well, we got mad about
that. We did get mad about that.
But why do we get mad about it? Because we love what we do. We care deeply about our clients, and we don't like it when laws come into effect that people don't understand and they disrupt family harmony. They hurt people, and this is going to have a really long-term effect on California. Right. You're going to start seeing it a lot in about 10 years, and then it's really going to get bad. Mm-hmm. So we're passionate about this, and please, Prop 19, if you can sign a petition to overturn it, please do. I want to change a little bit, and I want to talk about bad deeds. I'll talk about a deed that I've seen and had to explain to a client. And then, Rebecca, I want you to tell a few stories about things you've seen. I had a potential client call me, and she and her husband bought a piece of real estate with her brother about 10 years ago. And we're chatting, and something she said kind of made me wonder. And I said, would you mind giving me the address? I'm going to drop right into the database while we're talking on this Zoom that we're in. And I want to look at the deed. And so I pulled a copy of the deed and I showed her and I read it to her. I said, how do you think you own it? She said, I own a third. My husband owns a third. My brother owns a third. No, on the face of the deed, she and her husband owned 50% community property with right of survivorship. And the brother owned 50%. And it was not clear at all as to between these two 50% owners, it didn't say joint tenancy, and it didn't say tenancy in common. It didn't say anything. She lost her mind. And her brother, I don't need an estate plan. I don't know what you're talking about. I don't have any kids. I don't care. I haven't heard from her, even though I keep pinging her, and I'm hoping that she's cleaning this up. But that's really common, is that people are very, very sure that they own it a certain way. And I asked her, who drafted this for you? Oh, well, there was a realtor, there was a title company involved, and the lender, no lawyer. What is her remedy? How does she fix this, Rebecca?
Well, it depends. So you don't have to do it, and we're going to do attorney talk, right? This is not legal advice.
Oh,
right?
absolutely. We can't
This
give
is not
anybody
legal
legal advice because the answer is it depends.
It depends. But you could potentially correct the vesting. The problem is not the problem. One of the problems is because they've identified proportional ownership. Guess who's going to get reassessed if they change that proportional ownership? Because the county, they're like sniffing for that.
Yes.
They're going to get tagged. Let me tell you a really fun story about changing the proportional ownership and what we did. So I was working with a brother and sister. I was representing the sister. They had a really bad breakup. They owned a bunch of property in LA, and they were going through a really bad business breakup. Both of them came into this business relationship with property that they had acquired prior to establishing this relationship. They created one LLC and dumped a couple properties in it, and they created another LLC and dumped a couple properties in it. That's a story for another day on why we might not want to do something like that. But what they did was on some of the properties, they went right from sister into LLC or brother into LLC, but some of them, they went sister, add brother, then dump it into the LLC. Okay, great. So now we're breaking up this relationship. They're not selling these properties. They're basically parceling them back out to whoever brought them in. How do we keep them from getting tax reassessed to the whole value? Because they bought these properties low market, right? We're talking like 2008, 2009, 2010, market crashed, property values are really low. Now they're in LA, it's 2020, 2021, values have basically doubled. How do we keep them from being brought back up to market? We can minimize the risk. So what we have to do is we have to step it out, and we have to show when we're submitting these forms to the county how the proportional interest is changing. And then we have to move it back into a new LLC to protect these guys on the business investment side. But that was one, like, they didn't talk to an attorney about how do we bring assets into an investment, right? So one, they're dumping a bunch of assets in one LLC, and it's just like, you got one sick property and you're going to have a bunch of sick properties, right? But they didn't also talk to anybody about what does this mean when we add other people to title, and then when we put it into an LLC, and then what happens if we break up? The tax reassessment between, I think we were dealing with 9 properties. It was an obscene amount of money that they were going to be reassessed. We were able to carve off portions of it, but it was only because somebody had the foresight, and it was me. Because they were getting ready to just go from one LLC and dumping it right into the brother or the sister's new LLC without actually stepping it back out and then pushing it back in. They would have been reassessed at 100% if they did that, one LLC to the other, because the proportional interest changed entirely. So that's one of my fun, how did we screw up this deed so bad stories. But I have similar stories too, where, they own property with family members, and they're like, oh yeah, well, we definitely own the property this way. And when we actually pulled the deed, we're like, you're not even on title. What do you mean I'm not even on title?
Yeah.
I can't tell you how many times that's come up where they didn't even know they were on title, or the situation where, and this comes up a lot in military families, because the spouse doesn't have the credit to qualify for the loan, and the primary borrower is the service member. They will ask the spouse to sign an interspousal grant deed, quitting off their interest in the property. They don't know what that means because nobody is there to tell them, hey, by the way, you're giving up your rights in this property by signing this deed, and you're going to be fighting about it when you go get divorced. But they're like, what do you mean I'm not on title? I was like, that's what you signed. That's what the interspousal is. You gave up your rights to this property. And they're like, nobody told me that. That's because you didn't ask. Well, I didn't know I
No,
needed.
and what they're hearing from the title company and the lender is, it's normal. We do this every day. To which I respond, you hurt widows every day. You hurt people every day. You are irresponsible. This is the unauthorized practice of law, and I don't like it.
We should get a billboard.
Really.
Can we get a billboard? We should get a billboard and put that out there. But that's absolutely right. It's like, well, this is how everybody else does it. And like, that's the story that I hear all over California with this is how we do it. Just because this is how we do it doesn't mean this is how it needs to be done. If somebody is asking you to sign a deed, stop and ask yourself why, and then call your attorney, because you do not sign anything. Don't sign anything, especially a deed.
And remember, everybody needs an estate plan. You turn 18, you need an estate plan. You should see your estate planning lawyer every 3 years, because laws change, things change. So when Rebecca says call your lawyer, if you don't have a company, if you don't have some other real estate lawyer, because you're a real estate investor, if you don't have that person in your life, your estate planning lawyer is that person, and they should be really well connected. And they should be able to say, send me the deed, or I'm going to introduce you to Rebecca or someone like her, or maybe it's going to be a family law attorney because you don't understand the characterization.
Right.
Come back to the hub and we will help you find the right person. And if somebody turns this into an emergency, listen, someone else's urgency is not your emergency. It's not. It's really important to get this stuff right.
I want to really highlight that, because in real estate specifically, it is always urgent. You have really short timelines in which you have to respond. You have, typically 30 days to get from the time you put in your offer until the time you get the keys. It's like 30 days for most people. And there's a lot of stuff that happens, and everybody's gonna be like, sign this, sign this, sign this. And there's going to be literally hundreds of pieces of paper that you're going to see and sign and probably not read. One of those things is going to be your vesting, and you're going to be like, I got to get this done as fast as possible because I have 3 days. You have 3 days from the time that you submit your contract to escrow to respond to their escrow instructions. And if your seller is a stick in the mud about it and you don't deliver that, they could send you a notice to perform and then cancel the contract because you didn't get those instructions in on time. That's not a lot of time to talk to your attorney about how do I hold title, which is why you should be having that conversation before you even put your offer in, because you already know, great, this is what we've done. We've talked to our people to say this is the best tax treatment, this is the best legal treatment. So when I get that form from escrow, I can confidently say, this is who needs to be on title, and this is the box that we're checking. But I wanted to say something. You said something, an 18-year-old needs an estate plan. The second you buy real estate in California, you need an estate plan or to update your estate plan, because let's talk about the probate fees. Take it away.
Oh,
I know we've got like 7 minutes, but.
So generally in California, if you die owning real estate and there is no right of survivorship on the face of the deed, it's going to fall into probate. And what that means is it's a court process. And maybe a million years ago, or even 70 years ago, these numbers made sense. When houses were worth $30,000, maybe paying 4% of the value of the house to the executor, whoever that might be, and then also to the lawyer, whoever that might be, was reasonable. Now that your house is probably worth $1 million in California, tens of thousands of dollars later,
right off the top,
will transfer right off the top. And if what you own is the house and you don't have a lot of other liquid assets, how are we even paying those tens of thousands of dollars? It's a mess. I want to see you when you're thinking about buying real estate, because once you buy it, if you're a first-time buyer, it's going to eat you alive because it's too exciting with the rugs and the window treatments. If you own real estate and you haven't done this trust work yet, it's critical. You have to get with an estate planning lawyer.
And I fully endorse that. Like, if you own real estate and you don't have your estate plan done, the amount of money that you'll spend updating your estate every 3 or 5 years will not even come close to the amount of money that your family is going to spend in probate fees, because we're only talking about one asset, just your real estate. let's say you own more real estate or you have other assets that are going to be subject to probate, right? Typically, the real estate is going to be the most expensive, but like just get it done. Because
honestly, lawyers make more money off of probate than they do estate planning, but it would be malpractice if we told everyone, you don't need a trust, just get a will and then we'll do the probate.
if I had $1 for every time I heard, I just have a will, isn't that enough?
No, a
No, it
will
is
is not
absolutely
enough.
not enough, because what do you have to do with the will, Patricia? Probate it.
Probate. If you do
Probate it.
nothing, probate tens of thousands of dollars. If you have a will, probate tens of thousands of dollars. If you
Yeah.
have a trust, no probate. Privacy for your heirs. People don't know what they are inheriting. Really good positioning for a surviving spouse. And we can draft a lot of very careful language around protecting an heir from the perils of inheritance, which
Right.
are creeps, predators, creditors. There's a lot that we can do with the trust that goes beyond simply the savings of tens of thousands of dollars for the real estate investor.
And I'd like to end on one tip. If you have a trust and you're refinancing your property, chances are your lender is going to ask you to take your property out of the trust. I know she's closing her eyes. If you can't see her, Patricia's closing her eyes. It happens. And I can't tell you, in another life, I worked at an escrow company in California before I took the bar exam. And the amount of times that I dealt with borrowers who were like, well, the property's in my trust. And I was like, no, it's not. And they're like, but I did my estate plan, it's in the trust. And I was like, no, you refinanced in 2007 and they took it out. And they're like, what do you mean? And I was like, they took it out and they didn't put it back in.
And let me add to this, Rebecca, because this happened to me. So I'm an estate planning attorney, right? My real estate was in the trust, community property, right of survivorship, me and my husband. I get the escrow papers. I read them all. I see the draft deed they want me to sign. No, because they pulled it out of my trust as a joint tenancy and popped it back in the trust as a joint tenancy. They wanted me to sign two deeds. So I said, no,
in the first place.
Maybe you guys didn't see my deed, but here's my deed. Here's my whole chain. And you guys have to revise this. And they refused. And so in order to get this really incredible deal that we got, we had to sign them as is. I was told by my mortgage broker, by the title company, and by through telephone, you're like, well, the lender said that it's fine because it's in the trust. What you have to understand about your trust is that it's like your computer, garbage in, garbage out. So what happened? My mortgage broker paid my family law attorney $1,500 to correct the title because I'm not messing around. That was the unauthorized practice of law, and I would not accept it, and I would not back down. I got the interest rate that I wanted to get, but I forced them to fix it. You have to be really, really careful when you do a refi. Let a lawyer look at the deeds. Let Rebecca look at all of your escrow instructions and all of those little niggly things, because it's really easy for these kinds of things to get screwed up. And after you die, the lawyer who's working on your estate might not think to go all the way back into the chain of title to see how you actually owned it. And if the last thing they see is a joint tenancy and nobody thinks, oh, well, maybe it was a community property and we can get a better tax outcome. Now you've hurt a family. So it's you've hurt your own family. So it's really important that you work with an estate planning attorney that pulls your deed. And if they see that there's been a pop in and out, that they go way back. Well, how did you always want your lawyer to look at the deed from when you acquired the property? It's not just the last one, it's how did you acquire it? Because you don't just get to magically change it. If you took title as husband and wife, whatever the heck that means, and then you did a refi and you popped it into the trust as community property with right of survivorship, I don't know if that's going to work. I don't think it does.
It doesn't. You're missing a deed in the middle. You can't change the nature. I mean, you can't change the nature. If you were just on title as husband and wife and you dump it into the trust, and in your trust, you identify it as community property, that's a big no.
It's all a big problem.
It's a big problem. So like whenever you have questions about your title, just ask. If you ever have questions about your estate plan, just ask. If you haven't done it, for the love of Pete, just call Patricia.
We're here. I'm going to put my website in the chat, and it's very easy to reach me and my team. And I have put Rebecca's website in the chat also.
And I will put my full contact info in there as well.
I hope we scared you enough to not do your real estate alone. I hope we scared you enough that if you're here as a professional, that you're not going to let your clients do this stuff on their own. If you're a financial advisor, I'll pull deeds for you. Let's get down to it and let's understand how our clients own real estate and what we can do to help them. Because
Absolutely.
when they're dead, it's too late. And if you think you're not going to get yelled at, you are.
Yeah. Yeah. I mean, especially if you're a professional that's, in the room, or you're watching this later, and you ever have, like, if anything ever sniffs of estate planning or real estate, just ask the question, right? We would rather answer this question 1,000 times than get
Yes.
the phone call from you or your client that says, we did this and now we're in this trouble.
Yeah.
Because, I mean, what is that old adage? An ounce of prevention is worth a pound of cure, or something
Yes.
like that, right? Just call, ask the question. Even if you think this is the stupidest question ever, like, how do we own this property? Just ask. It's
Yeah.
not a stupid question.
Not at all. And when I ask people, how do you own the property? They say the bank owns it.
Yeah,
I mean, it's really common. It's really common, right? How the hell? I don't know. That's like asking me how to fix something in my car. I don't know. There, I have words. I don't know what they mean. So estate planning is complicated. All law in California is complicated. Tax in California will give you an extreme headache. So we are here to help. Rebecca, I learned so many great things. Thank you so much. And this is being recorded. Thank you, everybody who's here. And if you're on the recording, you can reach Rebecca at Your Home Legal APC. And her phone number is 619-377-6533. And I can be reached at info@defontelaw.com. All this information is also in the Eventbrite. We're very findable, very reachable, and we work with clients all over California. Thank you so much.
Thank you. This was very, very.
Hello,
Hi.
hello.
Hi there.
So, Patricia, I found out about this Eventbrite through a Facebook group called like Newbie Estate Planning Attorneys or something like that.
Oh, great.
So I practice immigration law, and so I work with a lot of families. They always have questions. So I was like trying to learn more mainly about this because I don't practice it. But I find your approach to estate planning like super useful for real people. So
I'm so
I
glad.
feel like
I'm so glad. When I think about immigration, when I talk about estate planning as a social justice issue, let's think about a couple and he gets deported.
Yeah.
How does she have access to everything she needs? How does she go to his company and say, I need his last paycheck? How does she go to the bank and say, I need to get into that bank account to pay our rent?
Yeah, and that's a real problem because people get detained and don't have access to their own bank account to bail out.
Exactly.
So, and then obviously, like, there's a whole issue with different status families, and U.S. citizen children, and maybe a parent who doesn't have status. So, yeah.
What are the real estate concerns when it comes to that, Rebecca? What does it mean?
Those are fun. Well, talk about, because you don't have, this is one of the other things, is you do not have to be a U.S. citizen to own real estate in California.
Yeah.
So you can come over illegally, right? And you can buy real estate.
Mm-hmm.
There's issues on the back end when you sell it for tax purposes, but you don't have to be a U.S. citizen to own real estate. So let's say they're, an undocumented family. They own real estate in California, and one of them is deported, or both of them are deported. Mm-hmm. Let's say they have, let's add another wrinkle in there. Let's say they have minor children who are U.S. citizens, mm-hmm. who can't do anything, and they haven't done an estate plan, so there's no temporary guardians, right? Mm-hmm. Or permanent guardians, so those kids are in foster care. Like, there's so many problems. But specifically for the real estate, let's say the husband is deported, and the same situation with the bank and the business. She needs to go refinance the property because that's the money that she's going to use to pay you to get him back in the country or to stay in the country. She can't, because he's detained somewhere, or he's in Mexico or Colombia or wherever, fill in the blank, and we can't get a power of attorney, or they don't already have a power of attorney. And then you're dealing with the added layer of title companies don't like powers of attorney. You have to go through so many hoops, especially if there's a power of attorney already in existence and not one that they prepared, right? So they either have the wrong power of attorney, they have one that's too old, or they don't have one at all.
Oh, they don't like them if they're too new. They don't like them if they're too old.
They just don't like them. And I understand, like, there's a lot of risk in power of attorney, but you know, for your client that's been deported or detained and their spouse needs to deal with any of their assets, like if they don't even have just that basic, get a power of attorney so that your spouse can handle your affairs in the event that you're picked up. And if
You have to be
if you're dealing
careful.
with real estate, you have to have one specifically for real estate, because
Yep.
California title companies won't take a general power of attorney, like 9.5 times out of 10.
And
Oh, I didn't know
in the
that.
ones that I draft, we're very careful to include detention and disappearance
Yes.
as triggers. So it's not just you bonked your head. It's you've been detained at the border. You look like me, you're a US citizen, and you were protesting in Portland. You've been disappeared by the federal government.
You've been
Your durable
disappeared.
power of attorney is triggered. It's
Right.
for everyone. For everyone.
Yeah. But those, you know, developing that type of relationship with an estate planning attorney, I'm pointing over here at Patricia, to help your immigration clients protect their kids and protect their businesses and protect their real estate. Like, developing relationships like with Patricia are going to bring so much more value to your clients. Not only are you getting them to stay in the country legally, but like you're giving them the whole picture. So
Yeah.
I love this.
That's
I love
awesome. I'm glad you're here.
interdisciplinary study groups, and that's what we just turned this into. It makes me so happy. Are there any other questions?
I think Afimi had opened up her mic. If you want to chime in or ask a question.
No, I didn't want to chime in. It was just pretty enlightening for me. I'm an insurance agent, and I do have clients that buy properties and what have you, and some of them is just investment properties, and they have a lot, and we have life insurance tied to it for them. And so I never thought that this would be actually something that I would really, really need to know about until you guys started talking. And I was like, okay,
Awesome.
I need to
Makes
know
me so
this
happy.
because they ask me questions and we get to talk. I'm like a trusted advisor. And if I know this, then you can bet I'm going to be watching the video recording again and again and again, just so that I don't leave anything out. And this is also useful personally. Like,
Well, great.
when you have deeds, I have clients that ask that, oh, they have a baby, they want to have a trust, set up a trust for their child and all that. So now I know where to go.
Yeah.
And I want to
And-
make the point that if you have one really good advisor in your life, if you have an awesome insurance agent who calls you every year and makes you go through did you get a dog? Did you buy new jewelry? What art is in the house? Like, they're really pushing you. If you have a terrific financial advisor who doesn't just send you notes and newsletters, but actively seeks your company and wants to be with you. If you have a great estate planning lawyer who chases you around and tries to get you into the office every 3 years, a really good corporate counsel who sets up your LLCs for you, that's your starting point. Because ask them, how well networked are you? Do you know people who do the following things? Here's my problem. And sometimes you don't even know who that professional is. Just share the issue, and your trusted person can help you fill out the rest of your list of advisors. They can introduce you to the right team.
Yeah, that's one of my favorite things to do, is ask that question. Who else do you need to know?
Yeah.
Who else do you need? Who's going to make your life better? And that's where building these types of relationships, especially for the other professionals in the room, that's where you bring the most value to your clients. It's who you know. Which I don't know how many of you grew up actually hearing that it's all about who you know. I didn't realize until much later in my life it is actually about who you know.
It is.
Yeah, but it's cool. The insurance is also part of some. I mean, that's something that I talk about with my clients all the time, especially with my real estate investor clients. Because a lot of times these guys are coming in cash, so sometimes they don't necessarily think about getting insurance because they don't have a lender saying you have to have insurance. So they're either buying, internet insurance, and they're not, they're going and shopping the cheapest rate, and they don't know, they're not covered enough. And then we also have the conversation about, well, do you have a general liability policy, especially if they own multiple properties? And they're like, I don't know. So knowing good insurance agents for real estate and for just life in general is so important. So
And
thank you
always
so
life
much
insurance for whoever it is you own this real estate with, or if you die, who you're leaving it to, is there enough liquidity to pay off the mortgage?
Right. Yep.
It's a big deal.
And I
It's a
think,
it's all a
we
big
talked
deal.
about it a little bit earlier, the probate fees, right? They totally disregard how expensive it is to sell the property. So they don't care about the commission. They don't care about the mortgage. So if you're max, like let's use a VA loan, they can do 100% plus closing costs, right? They go and die and there is no equity to pay it. Where is that money coming from?
And the house is worth $1 million. And so what is this percentage based on? The fair market value as determined by, I don't know who,
Right.
right? Whoever the judge appoints, whatever
Yeah.
number the judge accepts. So it's not your equity stake. It's not, well, we only own $200,000 worth of this $4 million house. Those fees are calculated on the 4 million. So
Mhm.
this can truly, truly be punitive.
Yeah.
It's a terrible setup. I don't know why they don't change the numbers.
I don't even know if anybody's even asking the questions about changing the schedule for probate fees based on the values, specifically because of the issue with the cost of real estate in California.
It's madness.
I don't know. We should go find out.
We should. Rebecca, thank you so much for joining me. This is
Thank
my
you.
new thing where I meet an amazing expert and I think, well, I'm not just going to grind them into dust and get all the information out of them. So I'm a better issue spotter and a better lawyer and counselor. I'm going to interview them in a video so that everybody can benefit from their expertise and passion about what it is that they do. I'm Patricia DeFonte. I'm an estate planning attorney. We practice estate planning with heart. No, you get your money when you're 25, 30, 35. At my firm, we're going to dig a little bit deeper. We're going to take better care of you. Rebecca, thanks for being with me today.
Thanks so much for having me.